morning, and thank you for joining me on the path to liberty. It's Wednesday, June 19th, 2020. And on this episode, I'm going to be talking with you about qualified immunity. I'm going to briefly go over what it is. I'm going to point out that the Supreme Court on Monday rejected 10 petitions to actually get rid of it or even change it or limit it. I'm going to go through the history of it, going all the way back to 1871 and pointing out where it kind of got its start, and then explain how the federal court actually cemented it through precedent on the federal government and then forced it on all the states and created a serious problem for everyone. And of course, I've got some great quotes on the judiciary from Thomas Jefferson and James Madison. But before getting to all that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. We are on a bunch of live streaming video channels. Primarily YouTube, Facebook, DLive, Twitch, and Periscope or Twitter. I hope to expand that elsewhere. We're also on some archive-only video channels. Maybe we'll get some live streaming action there in the future as well. Library, lbry.tv, Brighteon.com, BitChute.com, and BitTube.tv. We also have the audio-only podcast editions at iTunes, Spotify, Stitcher, Google Play, Podbean, and elsewhere. You can find all of those archives, all of the individual shows, all the different platforms, and in each show I include links to a bunch of other reading. I will cite original sources on this episode, plus a number of articles so you can read and learn more. I'm only giving you an overview in the next 30 plus minutes. You can also find our email newsletter to sign up for, our social media platforms, and our membership program where you can support us for as little as $2 a month. And trust me, we make it go a long, long way. It's like a David versus Goliath at all time, the amount of money that we raise compared to the opposition. Find all that information and more over at 10thamendmentcenter.com/path to liberty. That's all spelled out. Again, 10thamendmentcenter.com/path to liberty. A quick hello to everyone out in the live chat. I'm very grateful for you joining me. I'm always so, I think about this, and when I started this organization, or I just started a website to do a blog back in 2006. I'm like, man, I hope to just reach a handful of people. I'm just going to say what I believe in. I feel it's incumbent upon me to share what I see as the truth. And I guess truth is something that reaches a lot of people, generates some interest. So what I thought would just reach a handful of people is definitely a lot more. Here we are years later. Anyways, hi to everyone in the live chat. Thank you for joining me, whether it's live or in the archive. Heather Rossi, Melody Skaman, Patricia Dance over on YouTube, Justin Morrison, Jane Peterson over on Facebook, Tyler B, Dan Warsaw, Denver Libertarian. Good to see you, buddy. Hey, this should be a fun one. Denver Libertarian says, Blue North win. Shane Lackey says, caveat emptor, Too Tall 509. Anomalia, Daniel Blanchett. Always good to see you, Daniel. And Anomalia, Sharon, MRGF 78, Jeremy, Alexander, Timothy Martin, Dustin Niels. Dustin Niels says you're doing great work for freedom. I am doing my best. I'll tell you that. I'm just going to keep doing, no matter what the odds are. I believe it's our duty to do what's right. And for us at the 10th Amendment Center, that's to promote the Constitution, every issue, every time. No exceptions and no excuses. I apologize if I missed anyone in the live chat. I will read through all of those later. If I get a chance today, maybe I'll answer a few questions, but I think this is going to be a pretty long episode, so I'm going to try to pack as much in as possible. Also, Tyke Conradi over on Facebook as well loves the show. That's awesome. Thank you. So first of all, let's get to this. I want to start out with some warnings from Thomas Jefferson, just to start it out to set the stage. And Jefferson consistently warned us. So many other founders did as well, from Samuel Adams and John Hancock to Patrick Henry and George Mason and many others. They warned us about the dangers of what they called consolidation. And I've done plenty of episodes on that. We've done lots of articles on the website covering that as well. So consolidation is centralization of power. If you're running a computer network, you don't like consolidation or centralization of power because in that situation, you have what's called a single point of failure. And that's why networks, they distribute. Information bounces all over the place. And some is stored here and some is stored there, and it's redundant. Because if one part breaks down, the whole system doesn't go. And even though the founders didn't put it in those terms, that's really the end result. When you have centralized decision-making, when they make a bad decision, which is way more often than the good ones, I mean, a broken clock, right? But when they make a bad decision, it is forced on everyone. And that's why they were so concerned about consolidation of power. Now, Thomas Jefferson repeatedly pointed out that he was concerned about consolidation being generated by the judicial branch. And I'm going to go through 3 letters, kind of back to back to back here, that he wrote later in his life. First one is 1820 to a guy named Thomas Ritchie. It was actually on Christmas, December 25th, 1820. And he put it this way: the judiciary of the United States is the subtle core of sappers and miners constantly working underground to undermine the foundations of our confederated republic, our confederated fabric. He wasn't talking about the Supreme Court coming in and decentralizing, because that was, a bad thing. He didn't like the idea of centralization. I will link to all these original documents in the show notes at 10thamendmentcenter.com/path to liberty, so you can read beyond just the quote, and you can actually get the full context of what he's talking about. But a follow-up letter to Nathaniel Macon the following year, November of 1821, he put it this way: our government is now taking so steady a course as to show by what road it will pass to destruction. He warned about this in the 1820s. He knew what was coming, the path to destruction, to wit, by consolidation first. So centralization of power would lead to destruction of the free government. And then corruption, its necessary consequence. So first consolidation, centralization of power, then corruption, which we have tons of today. Mind you, we have a very centralized system today. Most decisions are made by a central authority, or people appeal to a central court system to fix every problem under the sun. And there's plenty of corruption in the largest government in the history of the world, much of which we probably will never even hear about. Jefferson goes further to Nathaniel Macon. He says, the engine of consolidation will be, not might be, not could be, not it looks like maybe. He says it will be the federal judiciary. The other 2 branches, the corrupting and corrupted instruments. And then the third one I want to cover is 2 years later, a year and a half, March of 1823. This is a letter to William Johnson. I just have a meme up here, which is a paraphrase of it. He put it this way: there is no danger. Let me just add my quick aside: no danger. He didn't say this is one of the worst things, or this is kind of bad, or maybe this is going to be a real problem. He said there is no danger. I apprehend so much. At that point in time, he was so concerned about centralization of power from the judiciary. There is no danger I apprehend so much as the consolidation of our government by the noiseless and therefore unalarming instrumentality of the Supreme Court. So let's bring that fast forward to current times. And we've all heard a lot about qualified immunity. Maybe we don't know what it is. Maybe I'm learning a bit about it. I certainly am. And Mike Meharry and a number of other people have done a lot of awesome research and reporting and coverage on this. And I'm learning as I'm going through this, and I'm seeing a lot. I'm getting light bulbs going off as I go through this. What it is, where it comes from, and why it's a problem. It is just what Thomas Jefferson warned us about. Let's first go to the Cato at Liberty blog over at cato.org. This is from a guy named Jay Schweikert on Monday. So on Monday morning, the Supreme Court denied all the major petitions raising the question of whether qualified immunity should be reconsidered. I'm not sure if there were 10, but there were a bunch of petitions to go to the Supreme Court to actually consider a case and say, let's get rid of qualified immunity, or it's unconstitutional, or it was created out of thin air, or we got to restrict it, or something. And the Supreme Court said, no way, we're not touching any of it. They won't even consider it. This is, Jay writes, to put it bluntly, a shocking dereliction of duty. Now, many people may think this is shocking because they believe that the Supreme Court protects liberty, but this is utter garbage. Once in a while, it does something that somebody likes, and there's always one side or another of a political equation. So people think in general that it does good things. But as Jefferson warned us, the judiciary, the federal judiciary, is acting like a centralizing, a consolidating force, and that is incredibly dangerous to the structure of the Constitution, which fosters an environment where liberty has a chance. Not that it guarantees liberty enforced through the Supreme Court. So they think Jay thinks it's a shocking dereliction of duty. I think it is unsurprising that the Supreme Court is unwilling to overturn something it created. Jay writes further, as Cato has argued for years, qualified immunity is an atextual, ahistorical, judicial invention. 100% correct. which shields public officials from liability even when they break the law. Now, I've talked about this kind of in reference to people talking about strategy to nullify unconstitutional acts. We're often told, like, oh, you got to have your local sheriff arrest the federal agents. Setting aside the fact that most sheriff departments act as federal agents for the ATF, the DEA, and so many other federal agencies, and participate in federal task forces with the FBI as federal agents, more often than not participate in federal asset forfeiture sharing programs and the like. Even if they were all good guys, which most of them are not, they don't follow the Constitution, they take an oath, and they don't even understand it. I mean, we can blame government schooling for that, and that's another episode. But let's say they were all good people. The idea that some people tell me is that they should go out and arrest federal agents. Well, what happens when you try to arrest a federal agent who claims they're doing their job? The case, even if they try to do it in state court, if there's going to be a lawsuit, and immediately a federal court is going to come in and say, this is a federal issue, and they're going to move the case or remove the case to federal court. And the state judges will always comply with that. They're just going to do it. Now, maybe you'll find someone who won't, but in every case that I'm aware of, they'll just do it. And then once it gets into federal court, the federal court says, well, you've got immunity. You were doing your job. And they've actually had some history, and I don't have them off the top of my head here, but there's been times where they've done robbery and violence and things like that. And they say, well, this is just them being undercover. They have to play the part, so they're able to commit crimes and get away with it. That's just kind of an extreme example, but that's how it plays out. So Cato pointed out that Monday morning, the Supreme Court rejected any change to this. So here is what qualified immunity is. And this is from Lawfare blog, Nathaniel Sobel. I don't really like Lawfare, but this is a pretty good overview. Qualified immunity is a judicially created doctrine that shields government officials from being held personally liable for constitutional violations, like the right to be free from excessive police force, for money damages under federal law, so long as the officials did not violate clearly established law. Let's get to that. Where does it come from? Mike Meharry did a great article on this, going through the origins and the history of how this is played out and expanded. And he starts it out like this. We can trace the origins of qualified immunity back to the Civil Rights Act of 1871. It was actually more popularly known probably as the KKK Act. I think that was the phrase that they used for it. In effect, and this was in U.S. Code 1983, 42 U.S.C. 1983, Civil Action for Deprivation of Rights. In effect, it allows any U.S. citizens to sue a state or local official in federal court for the, quote, deprivation of any rights, privileges, or immunities secured by the Constitution and laws. It was really the first of federal laws that really was based on the 14th Amendment. Mike links to another article that says that he thinks it's probably an overreach of what the 14th Amendment authorized in the first place, but the notion was it was just going to be for limited situations, and maybe no one paid attention to people like George Washington, who in his famous farewell address pointed out that let there be no change by usurpation. Because even if you like usurpation being a theft of power, expanding power, even if you like the short-term good results, and I think there are very good arguments to be made that African Americans had a very hard time getting a fair shake in court in the South at that time. But you know, so a lot of people were very understanding of it. But Washington warned us that even if you like the short-term outcome or you like the policy that's happening right now, he said this is the method by which free governments are destroyed. Going further, that's a quick aside. Mike writes, although 1983 did not specifically provide for an immunity defense, it did not actually say that they could have immunity. They said they could be sued. That's it. And it was under very specific situations. Lawyers for government officials, surprise, often argued for immunity based on common law, arguing it was implicit in the statute. So this was a case-by-case basis. It just wasn't really a precedent. It wasn't considered part of the law, but sometimes it would make an argument for it, and sometimes they would get it, sometimes they wouldn't. And I think that is probably a better approach to things than how it is now. And we can fast forward to 1967, a case called Pearson versus Ray. This is where the Supreme Court cemented the doctrine of qualified immunity into federal jurisprudence. You'll find a lot of people saying they invented it out of thin air, and I would say that that's probably a misstatement. I say that myself, and I think it's probably wrong as I read through this, because we know that people were arguing for this qualified immunity thing for many years. It just wasn't super common. It wasn't automatic, basically. It wasn't the default. But in 1967, that's where the federal court cemented it as part of the process. The court held that government officials, Mike writes, who violate the law or constitutional limits on power in, quote, good faith can raise qualified immunity as a defense. So that's where it became part of precedent. And if we understand stare decisis, then we know that the court looks to precedent before they look to the text and foundation of the Constitution. It's basically, they treat the Constitution as what the Supreme Court says it means until it changes its mind. It's not what the founders and ratifiers say it meant. It's not the original legal meaning. It's what the court has enforced on all of us. And that's a huge problem. And we'll see how that plays out here in a moment. Mike writes, the next step forward for qualified immunity came in the 1971 case, Bivens versus 6 unknown named agents. The case opened the door for individuals to sue federal government officials for violations of rights, given that Section 1983 only applied to state and local officials. So first, it was originally going to be used here and there on a case-by-case basis because people brought it up and some judges said, well, okay, you can do this. Well, actually, we can start it out with, it's possible that the original act in 1871 was an overreach of the 14th Amendment, and then it was used. Once it was starting to be used, then they started arguing once in a while on a case-by-case basis for qualified immunity. Then in 1967, they established the precedent that they absolutely can do this. Then in 1971, they said, well, now we can also do this for federal officials. Or now they can do it going further. In 1982, it was Harlow versus Fitzgerald. It established qualified immunity for federal officials and set the stage for the current definition of qualified immunity. The court held, Mike writes, that government actors are entitled to qualified immunity due to, quote, the need to protect officials who are required to exercise discretion and the related public interest in encouraging the vigorous exercise of official authority. I mean, don't hear a lot about following the Constitution. Don't hear a lot about, like, well, if they violate the Constitution, well, that's a problem. It's just we got to protect government officials because government officials protect government officials. And the federal courts are part of the federal government. So, of course, they're going to do this all the time. And the current version of this now is that the courts basically analyze each situation under a 3-part test in a case called Graham versus Connor in 1989. A guy named Elon Werman explained the test in a paper called Qualified Immunity and Statutory Interpretation, which was published in the Seattle Law Review. And he writes this. This is just a quick excerpt of how he describes this. He says, even if a court decides that the use of force was unreasonable and thus unconstitutional, so they can even say, like, it's unreasonable and unconstitutional. They still have to go to another step. You can't sue them at that point. Oh, yeah, well, it was unreasonable and unconstitutional. But the second step of the inquiry is if the qualified immunity analysis was it, quote, clearly established that this kind of force in this circumstance is unconstitutional. If not, the officer escapes liability. In other words, they basically had to have the exact same situation come before the court before and held it. So, like, there's so many different permutations of how things play out that the odds of it actually ever being something that's, quote, clearly established, that they know that this situation, they can't do this thing, is almost impossible. Here in the appeal from Amir Ali and Emily Clark last summer, they write this. Since the Harlow decision, the court has made it exceedingly difficult for victims to satisfy this standard. To show that the law is, quote, clearly established, the court has said a victim must point to a previously decided case that involves the same specific context and particular conduct. Again, the only way you can sue a government agent in court and win is if the exact same clearly established conduct and context have already been ruled on, I hate the term ruling, by another court in the past. So basically impossible. They go on, they say, unless the victim can point to a judicial decision that happened to involve the same context and conduct, the officer will be shielded from liability. And now they're all talking about cops here, but it's really any government agent, ATF, DEA, FBI, doesn't matter. It could be Waco, it could be anything. They're just not going to ever get in trouble, and they know it. They're going to get away with this stuff. And here from Werman again, the qualified immunity test poses an almost insurmountable analytical problem. The permutations are infinite. A given situation is rarely exactly like another. There will always be sufficient distinguishing facts to decide that there was no clearly established law. And a good attorney for the government is always going to be able to point that out. And we know federal courts will often just defer, especially if it's a national security thing. Oh, well, that's national security. Well, he had to do this or she had to do this. And that creates its own problem as well. Now, also, that was originally, they were doing this whole qualified immunity thing under common law. Well, eventually they decided that it was all Fourth Amendment. And that was from the Graham case in '89. And Mike writes it this way. It also established that all police excessive force cases involving arrests, searches, or investigatory stops must be evaluated under the Fourth Amendment and not under common law and not even under the Due Process Clause of the 14th Amendment. And not to get into too many details, but the short version is that the Fourth Amendment, like all of the Bill of Rights, the founders 100% said that these amendments were originally to apply to the federal government only. Then after the 14th Amendment, 50 years later or so, well, my math is bad, I went to government school, in the 1920s, the federal government said the 14th Amendment, passed in the 1860s, now required the federal government to enforce through the courts, primarily through the courts, the Bill of Rights on the states. And so now here we are in the 80s, they're saying, well, now all of these immunity issues are now Fourth Amendment issues, and they are all federal issues. So all policing then becomes a federal policing issue. And that in and of itself results in this. Mike says the end result of centralizing power, just what Jefferson warned us about, the end result of centralizing power in the federal government is worse than what was happening probably in the 1870s. Now, it's next to impossible. And he was saying that, but when Congress passed, let me back up, actually. He says the rationale for federalizing state and local police misconduct cases was good intentioned. And this is what I was hinting at before. He says when Congress passed the Civil Rights Act of 1871, it was next to impossible for African Americans to get a fair shake in many state courts, and government officials could abuse their rights with virtual impunity. So we can understand the motivation behind this. But the short-term thinking is what is problematic. And the centralization of power always leads to people in the future centralizing that power even further and then using it in a bad way and forcing it on everybody. So while that may have been a problem, Mike says the end result of centralizing power is worse. Now it's next to impossible for any person in any state to get a fair shake when challenging police misconduct. So in the past, it was some people in some states, and maybe we could have come up with another way to deal with that, but now it's everybody in every state all get the same bad treatment. Mike says through the incorporation doctrine that applies the Federal Bill of Rights to state and local governments, this system protects police officers in every city, county, and state in the U.S., from Honolulu, Hawaii, to, and I don't know how to say this, so anyone from Maine might help me out, West Quoddy Head, Maine. So I don't know why he included that one, but I guess it's probably the ends of the country is probably what Mike was doing there. So centralizing power, centralizing judicial systems, and forcing the federal courts to enforce these views when the federal courts can determine what the Second Amendment, the First Amendment, the Fourth Amendment mean, and then they can force that view on the whole country, the odds of having more liberty are pretty much zero. And the proof is all around us. And this is just one of the many, many examples. And Mike sums it up like this. He says, the very existence of qualified immunity, the fact that it even exists, that it's even a debate right now, reinforces an ugly truth. We can't trust the federal government to protect our rights. It almost always defers to itself. He says to government power. We can't trust the federal government to protect our rights. Of course, the federal courts are part of the federal government, and going to the federal government, the federal courts, to limit the power of the federal government is not just bad strategy. It is dangerous to the Constitution and liberty. And I want to just sum up one more here. This from James Madison. Let me see if I can pull the full quote. I'll just jump to the full quote here. This is from his famous report of 1800, talking about the Virginia resolutions of 1798 against the hated the Stamp Act, the hated Alien and Sedition Acts of 1798 that were signed into law by John Adams when he turned into the bad guy. And this is how Madison put it. The resolution supposes that dangerous powers not delegated may not only be usurped, stolen, and executed by the other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. Jefferson, Madison, and so many other founders warned us about centralizing power, relying on the federal government to protect our rights. They actually were more concerned about the federal government violating the powers of the people of the several states, and now people have flipped that on its head. That's not to say that states are good. States are awful, but if we really follow the money, and I've covered this in many, many episodes on many, many individual topics, if you follow the money, most of the bad stuff that the states do are either federal programs or they're funded by federal grant programs, all of which shouldn't exist under the Constitution in the first place. Taking a quick look over in the live chat. Barfo says, what is this incorporation doctrine nonsense? I'll include some links. You can read about it a little bit more. You've got Article 5 100% wrong. You don't know what it is all about there, but you can read, and that will be over at 10thamendmentcenter.com/path-to-liberty. Gerard says the war on drugs is currently why no lives matter, and of course we know that started out as a state program, but it was expanded and forced upon all of the country by FDR in 1937 through the Tax Act that he included. Marianne Overboss says, you people are creepy. No, we want to limit government. That, of course, is always a bad thing. She says, everyone is paid off or compromised. Barfo, of course, says, I'm not wrong. People who know the least about the Constitution are the most arrogant. And anyone who says that Article 5 means the Bill of Rights apply to the state have not read any of the ratifying debates. They don't know what the founders had to say about this, and they're making things up. So I appreciate you saying stuff, but it's nonsense. Jane says, fact is, we are all just tax slaves. Scott Lashua, in my opinion, the only solution is to abolish the government. Hold the bad actors legally responsible via common law grand jury. I'm not sure how we're going to do that, but interesting. Going further, he hate me says, seems like qualified immunity for public officials creates a kind of a legal caste system. I think that's a really good way to do it. Fuzzfork, this is the caps thing is always great. Only Congress can make laws, but of course the federal court has created its own law. They've centralized power, and they're forcing that bad view of everything on everybody. Alexander Helling says, lawyers may have a license to steal, but police officers and other government workers are protected from the courts because they're all working for the same employer. Absolutely. And he hate me also points out, shouldn't the Constitution be the precedent? That is the only precedent. I've done a whole episode on stare decisis, or maybe a short video. I've covered it on this channel in the past, and it's basically this notion that precedent supersedes the Constitution. If the courts have said something, that's all they care about. Shane Lackey, August 15, 1971. SCOTUS pitching a fit over this breach in public trust? No, they are on board and are perfectly willing to go down with the ship. Dan Warsa says, I'm beginning to take Lysander Spooner's side. And Spooner, like, all the good and bad things, whatever. Spooner had some really great writing. And I think one of the best things that he ever wrote was his paper on the right of the trial by jury. And I did an episode on that last year as well. Veritas Vos Liberabit. I'm always stumbling over these names, but I think a lot of them are pretty cool. Non-compliance works. The federal court must be held to task and charged with violating the Constitution and fired. Well, that's not something we're going to be able to pull off, but certainly it's up to the people. The end result, and I've done some episodes talking about how sovereignty, we hear this phrase, power to the people, but really under the system, it's supposed to be power from the people. And it's going to take at some point in time for enough people through their states and on their own, in their cities, whatever it may be, to start exercising their rights and taking things the way they're supposed to be, whether the federal government or the state government wants us to or not. It's going to be very difficult, but I think we have to set the foundation for that right now. And Citizen Deb says, after the Patriot Act, they can basically lock you up without a cause given indefinitely. The indefinite detention provision was actually through the 2012 National Defense Authorization Act. The Patriot Act basically kind of set the stage for that. that created the indefinite detention. So be wary when you're supporting the troops. You're generally also sitting aside or supporting legislation that really destroys the Constitution, because all of those must-pass military spending bills generally include a lot of garbage. Gerald McCauley over on Facebook says, the road to hell and tyranny is paved with good intentions. And generally, and that's what George Washington was warning about. And again, I keep citing this. James Madison originally drafted his famous farewell address in 1792. He was planning on leaving office after one term, decided to stay a second. He was convinced to stay. He put his own touches, I'm assuming, on the final version. So Madison and Washington, Madison was more in the middle. Washington was a little bit more big government, and people like Jefferson and Henry were the other direction. But Madison and Washington put together a powerful statement that even if you like the results of what you're getting, don't be on board with it. If you want to change the powers of the government, do it through the amendment process. That doesn't mean all changes in government are okay, but that's how you should do it. Don't do it through usurpation, turning a blind eye. For even if it's the good result, again, this is the customary weapon. That's how Washington put it. Washington, Madison, the customary weapon by which free governments are destroyed. Anyways, I will take a look over in the live chat a little bit later. I'll look through all the comments in the archive. I appreciate all the feedback, all the positive, negative, whatever it may be. If you enjoy the show, you found it interesting, educational, fun to watch, whatever it may be, please smash the like button, subscribe, get notifications, all that stuff. They're all free actions, reviews on iTunes, but all of those trigger the algorithm of the platform you watch or listen on, and so therefore it tells that algorithm to show the program to more people. And if you really want to support us, you can do so financially. I see a number of people out here who are members already, and we absolutely could not get this work done without your financial support. I don't want to pressure anybody else into joining, especially with the way they're debasing the dollar these days and printing and going insane with this. I mean, you'd think it's always the worst it can be, but the Fed and its backers keep making things worse and worse and worse, and eventually it's going to be really bad. So I understand for people who are struggling through forced government shutdowns, being out of work, and all this stuff, if you can't afford it, don't feel pressure. I'm going to continue doing this. But if you do have a few bucks a month you can throw our way, I would be very grateful for any consideration you can give to joining us as a member. That's 10thamendmentcenter.com/members, or just a one-time donation over at 10thamendmentcenter.com/donate. That's all spelled out. Thank you so much for joining me. Thank you so much for watching. I hope you enjoyed this show. I hope you learned something that's more important than anything. And I hope you have a great day. I'll see you on Friday here on the Path to Liberty.